Hi, everyone. Welcome to our virtual WISPA America seminar recording on developments on privacy rules. We hope everyone is happy and healthy out there. We understand it's a difficult time for a lot of people, so we are happy that you're at least able to join us virtually. We wish we could be together in Dallas, but alas, things have changed. Today, we're going to be talking about developments on privacy rules with some key people I think you've seen around the WISPA world once or twice. My face is probably the least recognizable face of the folks who you'll be chatting with today. I'm Christina Mason. I joined WISPA last year as Vice President of Government Affairs. I manage WISPA's outreach in DC, both on the Hill and with the White House and other administrative offices. Another guy you probably have seen once or twice in the WISPA world is Ari Storch. He's our strong man on the Hill. He has over 25 years in DC as a strategist, and he represents us well on the Hill. And of course, our strong woman of the day on these issues and always on many of these issues and beyond, quite frankly, is Janelle Trigg. As you can see, she is an accomplished attorney. She works with Steve Curran at Lerman Center. As you can see, extensive experience on these issues and beyond, including small business issues. And she's always our sure counsel on many items. So thank you, Janelle, for taking time out of your very busy day to speak to us on these issues. And I'll turn it over to you since you're kind of the expert in these things. So we would love to hear what you would like to talk about today.
Thank you, Christina. Well, greetings, everyone. First, thank you for the work you're doing during this health crisis. This crisis has demonstrated how important ISPs are to keeping everyone connected, to families, to friends, to schools, healthcare, business, government, news and entertainment, and even more. This crisis also amplifies the problems in digital divide in many areas, and your work as WISP, as fixed wireless service providers, is greatly appreciated because you're really making a difference in your communities. But with increased appreciation from us also comes increased scrutiny from others. And that includes regulators, legislators, and consumer privacy advocates. Basically, I'm hearing more rumblings about how much privacy and data security concerns there are during this crisis because everyone's entire life is now conducted online. So while regulatory and legal compliance may not be a top priority, we know how hard you are working on keeping your networks and your service and your consumers busy and online. During this peak of the crisis, please still keep certain compliance requirements in mind, and these are the ones we're going to go through. Basically, protection of your networks in terms of a cybersecurity concern, customer personal information, and overall just keeping that data and information secure. We have a very aggressive agenda today, and I'm going to roll through quite a bit from the state and federal level in terms of privacy and data security requirements. This includes what WISPA promised the FCC when the broadband rules were repealed a couple years ago. An overview of what privacy and data security is so we're all on the same page. What is personal information and sensitive personal information? Do you need a privacy policy? State laws such as the California Consumer Privacy Act, other state laws for ISPs only, federal laws, and proposed federal legislation where Ari is the expert on that and will give you a great overview of what's happening on the Hill. And last but certainly not least, cybersecurity. Before we get started, occupational hazard. This presentation is not intended to create an attorney-client relationship. This is more educational purposes. It is not offered as legal advice. And because these issues are complex, they are nuanced to your own business practices and your own risk, you're strongly encouraged to consult your own attorney if you have specific questions. And any reliance on this information, because it has to be customized for you, is taken at your own risk. Let's just quick overview. This is for your own information. WISPA made a promise to the FCC and basically to Congress as well as states that when the broadband privacy rules, the very extensive and egregious, I think, from a business perspective, rules were repealed, which was a good thing. We needed to assure the public that ISPs still care about privacy and are not going to abuse the relationship you have with your consumers. We basically pledged that we would still provide transparency. As an organization, WISPA did this on behalf of their members, that people would have consumer choice. Next slide, please. As well as data security and data breach notifications. This is on WISPA's website. Again, this is an overview. All of the major ISPs pledged to this. So this is a foundation that we're building this presentation on. Here's an overview. I can remember when I first started in this privacy data security area more than 25 years ago. If you can imagine, they didn't call it privacy and data security then. It was just internet. It was just e-commerce. They said that the internet is not regulated. Well, for something that's not regulated, there are quite a few entities involved in the governance and enforcement of privacy and data security online and offline. There's a range of federal agencies. The alphabet soup of Washington is what we call it. But that also includes your state attorney generals, local and state consumer protection and regulatory agencies, international consumer protection and regulatory agencies, and of course, the state, federal, and international courts. Quick overview, privacy basically is preserving the confidentiality of an individual person's personal information and recognizing that that individual has a right to control it. Data security is protecting it using reasonable practices and procedures and systems from unauthorized collection, use, modification, disclosure, and destruction. Here's an important part. It used to be called PII, personally identifiable information. And it was limited to your name and email address, postal address, something that could be used to identify a specific person. This was 20 plus years ago. Today, it is much broader and it relates to anything reasonably related to a specific consumer, computer, or device. And that includes an IP address, unique device IDs, cookies, GIFs, bots, everything that has to do with a website viewing habit, search or purchase history, anything that is linked to or associated with PI. That's the general definition across the country, except for California. California is unique. California is leading the nation in privacy laws. In fact, some of the very first privacy laws were adopted by California. But the new California Consumer Privacy Act is even more extensive than the things California has done before. It has changed the game. It has changed even the definition of personal information. Their definition is anything that identifies, relates to, describes. Here's the phrase that drives me nuts, is capable of being associated with, or could be reasonably be linked directly or indirectly with a particular consumer or household. What in the world does capable of being associated with mean? Now, for those of you that are not in California, please don't ignore this because you still may be subject to this California law. That's what makes this California, that's what makes CCPA so onerous as well as very difficult to implement. It applies to any consumer. California defines consumer as any natural person who's a California resident. And that includes employees, that includes vendors, any contractor you're dealing with, and it's every individual who is domiciled in the state, even though they may be outside the state temporarily or for transitory purposes. This could include students who live in California, have retained their address in California, but are now matriculating at universities in your backyard. So please, for those of you that are not operating in California, you may still be subject to this particular law if you have California residents in your service area. Here are the two general definitions of what PI is. If you can go back one more, please. Okay. One more. Great. Sensitive PI, that's your most sensitive, as well as personal information that is subject to identity theft. Generally, it's social security number, credit card, health information. Now it includes geolocation, personal information collected from children under 13, and CPNI. California adds to that list, and it includes biometric, someone's signature, physical characteristics, race and ethnicity, professional or employment related information. Again, California is above the norm. Next slide. The question I get asked the most is, do I need a privacy policy? The answer is yes, and if I could have filled that page with exclamation points, I would have done so. Not only do you need a privacy policy for good business practices, it is required in various states as well as federal law. States that require a privacy policy are California, of course, Delaware, Connecticut, Nevada, just a few. The FCC's Open Internet Transparency Statement, which every ISP, regardless of size, is subject to having posted on their website or filed with the FCC. That requires you to disclose your privacy and data security practices. And the absence of a privacy policy could be considered an unfair trade practice because you are collecting a long list of personal information from consumers without giving them information about how you're going to use it, who you're going to share it with, who you're going to send it to, as well as how you're going to secure it and how long you retain it. There are two worst things you can do related to a privacy policy. The first one is to have a statement similar to this one. We value and respect your privacy. We will not share your personal information with anyone. You think that sounds very good, very reassuring, but it's misleading, if not deceptive. This is a promise you cannot keep. Your privacy policy must reflect your actual business practices. Otherwise, your public statements are deceptive under federal and state laws. You will indeed share personal information from a consumer. It is perfectly acceptable to share because you have to run your business. You will share it with your payment providers if you have a third-party payment provider. You will share it with law enforcement when law enforcement comes along. You may share it with your affiliate company or your parent company for ordinary course of business practices. You're going to share it on a court order. You're going to share it if there's a regulatory requirement for you to disclose certain information. And you certainly will share it if you've got a copyright infringement issue, that a copyright owner comes to you and says, someone is downloading my material under the DMCA. You need to share that data with them. You share personal information. You have to share it to comply with other laws. So if you have any statement similar to this on your website, on your privacy policy, in your terms of use, please go back and remove it now. It is false. It is a lie. You do not want to have a deceptive statement. That second thing you can do is to copy, second worst thing I should say you can do is to copy someone else's privacy policy. I can't tell you how many privacy policies I've reviewed that I can tell was cut and pasted from someone else's, because the someone else's was the one that I wrote. I see my own language looking at me. And worse yet, I see the name of the company that it was copied from still incorporated in the privacy policy. Your privacy policy, as mentioned, needs to reflect your actual business practices, and it needs to include this basic information. What are the types of categories of personal information, your methods for collecting it, directly, indirectly, sometimes we say passively. Is it someone that's voluntarily submitting something to you, or do you access it by the nature of the internet, like IP address? Whether you share it with third parties, who and why, whether you track or profile for any purpose, not just advertising purposes, but do you use packet inspection, for example? Other unexpected uses of PI, you need to disclose that. How you secure it, how long you retain it, and how a customer can exercise their right to access it, delete it, or update that information. CCPA adds a whole nother list of things you have to put in your privacy policy. Notices an explanation of certain consumer rights. CCPA requires you to have a link that says, do not sell my personal information. Post it not only in the privacy policy, but at or before the point of collection, when you collect it. Again, the categories collected, purposes sold, and then what is sold in the preceding 12 months. And I'm going to go through what sell means. Again, do not sell in California does not mean do not sell. How interesting. Don't forget the other California laws that govern privacy policy. California has its own California Online Privacy Protection Act. Their Shine the Light Act. They have a browser, do not track disclosure requirements. If you are operating in California, you are surrounded or you have you're close geographically to California, you should be in full compliance with California law. Next slide. Here's a little bit more on CCPA. I'm just going to roll through these slides very quickly because I understand not all of you are subject to it, but I believe more of you are subject to it than you think. Here's who's subject to CCPA. A business that's for profit, does business in California, has gross annual revenues or shares 50,000 or more consumer, household, or devices. By the way, that sounds like it's a lot, but it only comes down to 137 things per day, whether it is a household, device, or consumer, or whether you get 50% or more of your annual revenue. The word selling, as I mentioned, is misleading, as well as the 137 per day. We don't know. California has not given us more explanation. We're still waiting for regulations. Whether that 50,000, is that just California consumers, or is it your global? Is it 50% annual revenue from selling just from California or not? We're not sure. The word sold is very broad. It doesn't mean just selling. In short, it means making available. Basically, if you make available any PII to a third party for monetary or valuable consideration, you have sold it. It doesn't have to be a normal consumer transaction. It is making available to another third party for monetary or valuable consideration. California also has not defined valuable consideration. There are a few exceptions. Fortunately, if you use or direct a business to disclose it with a third party, as long as that third party doesn't sell it, you can also share it. If a business uses or shares your consumer PI that they've opted out of the sale, consumers have a right to opt out. And here's the one that you really need to be very conscious of and understand. If you use or share PI with a service provider to perform a business purpose, you can only accept that definition if both of the following conditions are met. If that service provider performs the business on your behalf And they also don't sell it, but you must have a written contract with that service provider that must expressly prohibit the sale, and there are other reps and warranties required. So the service provider exception is important, because otherwise, if they don't meet the very detailed requirements under CCPA, when someone opts out of the sale of their information, a consumer opts out of the sale of information, you have to inform that service provider, and that service provider may also opt out of sharing that data. They don't get to use the consumer information. This includes your payment providers. If your payment provider, if the providers that provide your Census Bureau tracking for 477, Form 477 purposes, if they don't meet these requirements, you cannot use that business, that service provider, that third party. Next slide. As I mentioned, definition of consumer, only in California, includes employees. Fortunately, an amendment to CCPA, a hard-fought amendment, exempts PI collected from employees, job applicants, business owners, contractors for just 1 year. It will sunset in January of 2021, which means, yes, now you have to have a privacy policy as well as a whole host of consumer rights for your own employees. But note that that amendment did not exempt employers from the privacy policy notice or data breach liability provisions, which means your employee can still sue you if you have a data breach, if you have an unreasonable data breach of their data. Next slide. CCPA. Here's the problem with CCPA, a whole host of new rights. You must provide notice and honor a consumers. They have a right to request the general categories from you, right to request specific categories and what they collected from you, right to request sources where the PI was collected. They have a right to request business purposes. They have a right to request categories of third parties that shared and received your PI, right to request deletion of PI. Next slide. The narrow exceptions to deletion, which is good, this is one of the good things about CCPA, will exclude when you have to use it for business purposes. Here's a list of all the exceptions to deletion. Next slide. Businesses must also provide notice and honor a consumer's right to say no. Here's the problem that I mentioned, the sale of PI to a third party. If your third party does not meet the service provider definition and meet the requirements, you have to basically pull that data from that business. And you cannot discriminate against a consumer for exercising this right. You can't deny them goods or services. You can't charge a different price or provide a different quality, or they will get a different level of quality, price, or rate, or impose any penalty. The only exception to that sale, as I mentioned, is that that third party qualifies as a service provider. You have to meet all those qualifications. This means that you need to review every contract you have with every third party to make sure that contract meets the different reps and warranties, and they certify to certain to not sharing any data with their third party. Understand that it's not just the direct third party you have business with, it also relates to their third parties, their downstream vendors and service providers. Everyone must comply with CCPA, and it's on you to make sure that that contract and that written agreement includes the downstream providers as well. Next slide. Consumers have a right to make requests twice within a 12-month period. You must provide them with 2 or more designated methods to request this information. Fortunately, there was an amendment that if you operate exclusively online, the direct relationship, you don't have to have 2 or more methods. You can just have requests via email. You must have systems and databases in place to identify the information requested by a consumer. as well as a process to verify that consumer's identity, to make sure that it's that consumer that's requesting their information. And this must be done, lovely, all free of charge within 45 calendar days. There's a limited extension period, but basically you need to be able to comply with this pretty quickly. Steps to take now. This is your action plan. Assess what kind of PI you have in possession and purge anything you do not need. If you don't keep it, you don't have to be responsible for it. Determine if you sell. Again, sell means disclose or make available. Or do you meet the very few exceptions? Modify, review, please renegotiate any vendor relationship, any contract you have. Establish your systems and procedures. Training is another requirement. You need to review your computer systems, networks, and security of customer data. This is not just online data, this is all data. You need to draft your new privacy policy with the disclosures and statements, and then work on the design of your do not sell my personal information. Next slide. Other state laws. After the broadband privacy rules were repealed, and after the net neutrality Title II order from the FCC, which put ISPs in the category of common carriers, when that was repealed, there was as you imagine, a blow up. The whole world went crazy, particularly on the consumer advocacy and privacy side, that now the internet was going to come crashing down because ISPs were permitted to do all kinds of bad things with personal information. So there were several states that decided to impose additional obligations on ISPs only. And Maine was the most recent one. It's effective in just a few months. The Maine law is silent on enforcement and penalties, and there are very limited exceptions, but it prohibits you from using, disclosing, selling, permitting access to a whole host of information without the customer's express affirmative consent. And then you can't refuse to serve a customer who withholds consent. This law drives me nuts because it's not realistic. It shouldn't even have been adopted. It was a last minute type of changes and things to it. It's a mess. And there are other states that also have crazy laws, such as Nevada and Minnesota. Those two have criminal penalties and fines for prohibitors, for people that violate the law. Next slide. And there are other state laws that are pending that haven't been adopted, but we expect to see more and more given the rumblings that I mentioned from the very beginning about the concern about privacy and data security now that everybody almost in the world is conducting their entire lives online. Other state laws. Every state in the union has a security breach notification law, and there's many differences and nuances. There were new laws and amendments that went into effect this year. There are 8 new laws that are in effect, as well as changing when you have to provide notice. How quickly do you need to give information to a consumer about the security breach? Who you need to share it with? Do you have to disclose that you had a security breach to the FCC, to your state attorney general, to consumer reporting agencies? And then, of course, there are some states that actually allow the consumer to have a class action right to sue you if your security was not at a reasonable and you didn't take reasonable measures to protect their data. So the question is for everyone, do you have an internal security breach protocol and plan when you're going to respond to law enforcement or notify a regulator or a state AG office, but notify a customer when a security breach happens? Security breaches happen to good companies, even with great data security practices. So it's not a matter of when you're going to have a security breach. It's not a matter of if, it's just a matter of when. You need to be prepared before it happens. That is having internal policy. Other federal laws. ISPs of all sizes, particularly the smaller ISPs, are very vulnerable to cyber attacks from a domestic and foreign perspective. We're seeing more activity, of course, in the last election, major election, presidential election, there were, again, major concerns with Russia and China and other countries imposing or hacking or doing control and command access to ISPs. I have had several conversations with the FBI and Secret Service regarding some of those incidents. We expect there to be more this year. Of course, we've already seen some of it. So there are two particular laws that work together to help you respond to as well as protect your customer personal information. CP&I, which stands for Customer Network Proprietary Information, are rules that came out of a statute that came out of the 1996 Communications Act. And CALEA, which is the Communications Assistant for Law Enforcement Act. CP&I and CALEA are related, but they serve separate purposes. I get asked all the time, what's the difference between the two? CP&I, those are rules that govern how you protect the customer PI. CALEA is how law enforcement will access your network, your equipment, your logs, your consumer files for national security or other lawful purposes. Next slide. More on CP&I. There's an annual certification to the FCC for the prior calendar year. You have to certify that you've met all the elements listed below. That certification was due this past March, or I should say as of March 1. If you have not met all of these elements, do not certify. Your certification is under penalty of perjury. It is better to miss a certification than to lie on a certification. So if you did not meet all these elements last year for the calendar year 2019, you should not have filed a certification as of March 1. Next slide. The definition of CP&I is important because it's not just all PII that I talked about, it's more narrow. Phone numbers called, received, frequency, duration, location and timing of such calls, any services purchased by the customer, information contained in the telephone bill. It excludes a name, address, and telephone number. All ISPs must have a procedure and a designation for your CP&I compliance officer. That officer implements the operating procedures to ensure the privacy and security of your consumer. You need an employee manual, training guide, as well as enforcement, internal enforcement, which means you need a disciplinary process. There's no small business exemption. Every ISP has to meet this requirement. Additional obligations. Overall, you have to get your customers' approval to use, disclose, or permit access for marketing or other purposes. You have to notify customers of their right to restrict the use of their CP&I. You must take reasonable measures to protect against it. And that includes against law enforcement and other government entities. There are formal processes, there are warrant processes, there's court orders that law enforcement must have to access CP&I. You are obligated to review any request from law enforcement, no matter how egregious the potential crime or the action is, which is why they want access to it, child molestation cases or something. You want to help law enforcement, but you have an obligation to make sure that warrant, that request, that subpoena is accurate and is timely and it reflects the right information in there. So otherwise, you will have violated the CP&I rules, as well as a whole host of other laws. You have to notify law enforcement and affected customers when you breach CP&I and security breach notification requirements. Note the state laws we just talked about. So not only you're notifying your customer through the FCC's rules, but you have obligations under your state law. And then you must maintain detailed records of all disclosures and access a minimum of 1 year. Next slide. FCC just had a recent enforcement action, and we anticipate more, basically because the FCC is very active in the privacy and data security space since the broadband privacy rules were deleted. And there has been an uproar about this particular case, about the 4 largest carriers that shared and disclosed location-based information on an unauthorized manner. Location-based information is one of the most sensitive forms of CP&I. And worse yet, there was a 2018 New York Times article that reported on this potential violation of CP&I. The article raised serious privacy and data security issues, but yet the carriers continued to sell their CP&I to what's called a location aggregator without prior customer authorization. And that aggregator sold it to another third party who sold it to another third party, so on and so on. And then you've got law enforcement, I believe it was a sheriff in Missouri, that was able to go to this aggregator, access the CP&I of a particular citizen without a warrant, and that was disclosed in the New York Times article. The forfeitures have been over 200 million. For the life of me, I don't understand how in the world any carrier, particularly the largest carriers, would think that disclosing and selling location-based data of one of their subscribers was a good thing and didn't violate the CP&I rules. But go figure. CALEA, very quickly through this, you can check this at your leisure. It applies to all telecom and VoIP and broadband providers. Has been for some time. You've got certain CALEA requirements in order for law enforcement to access your network, access your system. Next slide. In addition to having your network and your system CALEA ready, you also have to file and maintain a system security integrity plan with the Commission. It is due within 90 days of a merger, divestiture, or amendment, which means if you bought a new company, you need to file, you need to keep it up to date. This is the information that must be included. This data is not to be made public. It's filed with the FCC, but it's not posted on someone's website. It should only be accessible to law enforcement. Next slide. Other CALEA compliance requirements in terms of adopting a manual and implementing your operating procedures. Again, to make sure that your CP&I rules is consistent. Single certification information, start date and time. This is all information that you must provide when you have an interception or access. When law enforcement comes to ask you for data, you have to have the name of the person signing the appropriate legal authorization, and of course the type of interception. This certification does not have to be filed, you need to maintain it. WISPA has worked with the FBI and other law enforcement agencies to coordinate what your CALEA requirements must be, given fixed wireless is more unique than trying to access traditional telephone communication systems. You can look at the CALEA standard that WISPA has worked on. It should be available on its website, on WISPA's website, or at the request email address below. As I mentioned, no small provider exemptions for CP&I or CALEA. You have to do both. And you must have your internal company policy to handle law enforcement agency requests. Otherwise, you can violate CP&I or other rules. TCPA, a new 4-letter word, which is probably one of the worst privacy data security, I can't say it's a worse law, but it's one of the worst violated or worst in terms of the consumer advocates and class action bar taking advantage of good companies. TCPA has a strict liability statute for companies, principals, and their agents, any advertiser, seller, or any entity that initiates a call using ATDS system. You can be liable for violations and can be a defendant in a class action lawsuit. Under TCPA, text messages are defined as calls. Under wireless email messages, upon a conversion to a phone number, that's a call. TCPA carries a private right of action with statutory damages from $500 to $1,500. This is per violation. If you text to your consumers alerts on when their bill is due or past due bills, if you text them when there are problems with the network, if you have not secured the proper consent, you are subject to potential class action lawsuit, statutory damages. If your customer base is only 10,000 people and you multiply that by the number of texts, unauthorized texts that you sent, that's your potential liability times $1,500. TCPA is very expensive as well as very risky if you don't follow the procedures and the requirements to the letter. These class action lawsuits have made millionaires out of single person law firms. At one point, I wanted to retire and open up my TCPA house in my garage, but I'm fighting on behalf of companies and not trying to get money out of companies for violations. Understand that state AGs can also bring civil actions on behalf of their state reps. So you should check your text messaging. There is no existing business relationship, by the way, exemption. So I've heard that their current customer, it does not make a difference. Current customers, past customers, you cannot send a text message or make a call to any mobile wireless device without certain consent requirements, period. Reassigned numbers. One of the things with federal TCPA, hardest part, particularly with ISPs and telecommunications providers, are sending messages to someone who you got the proper consent from, but whose telephone number changed, they moved or whatever. So I've seen many class action lawsuits that have claimed bought by someone who said it was not my telephone number, that was not the person they were trying to reach. So there's a problem with, and the FCC recognized there's a problem with reassigned numbers. And in light of some of the court actions and lawsuits, the FCC is working on technical requirements for trying to identify when a telephone number has been reassigned. And the carriers, as well as the number agencies, are trying to work with the FCC as well. When this database gets set up, it will help prevent unwanted calls and it will lower the risk of lawsuits. And we think that's very important. ATDS, the definition is important, determines what calls violated TCPA or not. Right now, it's very general. It's hard to tell. Every court makes a different decision. There are conflicting decisions across the country. Again, I'm just giving you this information as background to understand TCPA is nothing to play with. You have got to follow the law. Next slide. Fortunately, a single confirmation text message that someone opted out does not violate TCPA. Believe it or not, someone sued because they opted out of getting messages. You know, the text message that says stop, send us a text message that says stop if you don't want text message anymore. Someone sued because you replied, we received your stop message. Also, the good thing on the class action litigation is that the federal courts are now denying certain class certifications because there are multiple evidentiary and procedural grounds. There have been a couple of good cases, even one coming out of California, which has been a hotbed of class action lawsuit activity. Next slide. TCPA prohibitions, believe it or not, apply to VoIP calls, calls sent using the internet. They also apply to ringless voicemail. If you have voicemail messages that are delivered to an inbox without the phone actually ringing. These are all new developments on the TCPA front. TCPA prohibitions apply to robot calls. believe it or not, made by a live person that also incorporates a pre-recorded or artificial voice clip. Next slide. Single phone call. Again, we're hoping the Supreme Court would address it. They did not in this one, but hopefully in the case that just happened in this 2020, the Krakauer versus Dish, but the Supreme Court will address TCPA constitutionality this term, albeit it's toward different type of underlying action, but hopefully the Supreme Court will address ATDS because that will make our lives much easier. Next slide. Cybersecurity. As a critical infrastructure, and ISPs are very much a part of critical infrastructure as demonstrated during this COVID-19 crisis. You also have obligations to secure your networks and your systems and in turn secure the data. By the way, the page is just for your information of resources that you can go to find out about more requirements as well as some cybersecurity plans. Next slide. As I mentioned, cybersecurity, you have an obligation to protect your data, systems, networks, computers, all infrastructure. The FCC has a great cybersecurity planning guide for small business. There's the link to it. They also have other data security and cybersecurity guidance on the FTC's site, as in Federal Trade Commission. These are resources for you. As a small ISP, you still have cybersecurity obligations. Next slide. All right, I think this is your area of expertise.
I appreciate that, Janelle. Thank you so much. And, you know, I think it's really important. Janelle spoke very eloquently about the challenges CCPA faces, not just for you if you're actually in California. There is a large push for federal legislation to harmonize policy across the country because there are a number of states looking to replicate CCPA right now. I believe there's actually 13 legislatures with bills similar to CCPA, based on CCPA, that they are trying to move through their state legislature. So this could quickly blossom to a lot of states. And so there's a large drive at the federal level in a bipartisan way to really kind of inhibit CCPA spread on a macro level. Unfortunately, in the House, we do have the Speaker of the House, Speaker Pelosi, who is a Californian and does not want to see any bill that undercuts CCPA from California. However, the most important committee for the purposes, the House Energy and Commerce Committee, and particularly their Consumer Protection Subcommittee, are actually working very well in a bipartisan way to try to craft a piece of legislation that would harmonize and preempt the CCPA law in favor of a comprehensive federal law. There's one piece of legislation that has attracted some bipartisan support. That's an off-committee bill by Congresswoman Suzanne DelBene from Washington State, obviously a large technology contingent in her district just outside of Seattle and around Seattle, that the New Democrats have actually endorsed. It's a lighter bill, less comprehensive bill, but it does recognize that a private right of action and the risks private right of action could take, and so it does have a lot of provisions to limit private right of action. Let me review for you the priorities, and it's the same challenges we're dealing with in the House as we are in the Senate. The three major stumbling blocks we have to a comprehensive package are a private right of action, which would be, as Janelle's explained, class action lawsuits, and I'll explain some of the issues that are going on there. Preemption of CCPA and any other state laws. What should, how far can this go? And again, with the Speaker being a Californian, we know she does not want to see CCPA preempted for a weaker federal law. So that is a challenge for the committee to try and get over that hurdle. And the definition, as Janelle said, what is sensitive private personal information? there is still a significant discussion taking place in Congress on what is that sensitive information that should be protected, and also what punishments should there be for folks who leak or fail to protect. And that's kind of I say that strongly because it's not a matter of intentional, but it's also a matter of passive prevention of protecting this information that will take place. So those are the priorities that we are facing in the House. I'll walk you through just a couple of pieces on this. One interesting point on CCPA, there is no private right of action under the California law or a class action lawsuit in California. However, there's an attempt to use the Constitution in California that actually protects your privacy in general as a constitutional right in California. There is an attempt in California right now to expand CCPA, to add a private right of action into it, and frankly, they're looking at doing this in an executive manner rather than through a legislative manner. So
and Ari, there is a small private right of action for the security breach part of it, but not the regular privacy policy and do not sell part of it.
Correct. So we're monitoring all of that in an attempt to make sure, how that goes. What's interesting in the private right of action is there's a large debate in Congress about what defines economic injury. And also, would you have a right to sue for physical harm as a result of a data breach or failure to protect data, i.e., as Janelle mentioned earlier, location data, which is one of the most sensitive pieces of information. Let's say a stalker has found a way to access a woman's cell phone in order to track her down and then attack her. So the scope of the economic injury, there are those on the Republican side who want a proven economic injury before you're allowed to sue, which would kind of prevent class actions. If you couldn't actually prove you had damages before you filed a suit, and these are quantifiable damages, not just a fear, meaning, I stay up all night now because I'm worried about my data because there was a data breach. You have to be able to, Republicans would like to see a proven definition of damages before you are authorized, allowed to sue. So that's the battle in terms of the private right of action in the House. There's a case you should also look at and be aware of in Illinois that Facebook, and Janelle may have some more information on this, that was just settled, and Janelle also alluded to this. In the Illinois law, which Republicans would like to replicate, if the state attorney general brings an action against somebody who has failed in terms of a data breach, once the state AG settles the case, you cannot have a class action. That is another battleground that is taking place in the House. And finally, while we have two very good chairmen, Jan Schakowsky from Illinois, and a very good friend of the WISP industry, and Kathy McMorris Rogers is the ranking Republican on the Consumer Protection Subcommittee. And we've actually had a WISP meet with the Congresswoman personally from her district. A small business exemption is something I do not envision emanating from the House at this time. We have pushed for one. I do believe there is grave concerns about small actors who are acting recklessly, and they do not want to give a blanket exemption to a small actor who, to a bad actor who just happens to be small. So we're working in how to make this as least burdensome as humanly possible for our businesses. Christina, if we can move over to the next slide, I'm just going to walk you through what's been happening in the Senate, because we really think this is where substantive bipartisan legislation will originate from. We have an original working group that consisted of the chairman and ranking members of the two key committees of the Senate Commerce Committee. It was the chairman and ranking member of the Consumer Protection Subcommittees, and Senator Jerry Moran from Kansas, again, a very close ally and friend of the WISP industry. Senator Richard Blumenthal from Connecticut, a former attorney general. And at the time, it was Senator Roger Wicker, who is now the full committee chairman, but at the time was the chairman of the Communications and Technology Subcommittee, and his ranking member, Brian Schatz from Hawaii, who is a tremendous consumer advocate. So those four have been working together for well over a year, since last Congress, actually, trying to craft legislation. There had been great hopes at the beginning of this year, beginning of last year, before CCPA had really taken effect, that they could get a bill out there that would preempt CCPA. And I want to make another point here that's, to be clear, there's nobody in the Senate who has an illusion that you shouldn't pass a bill that preempts any state bill and becomes a single package and harmonizes federal policy. There's a good legal argument that this is interstate issues and interstate commerce in terms of digital and online world. So, and I think most senators recognize that. However, this working group failed to deliver a product. They were held up over many of the same issues, but I think we've gotten a lot closer in the Senate to the definition of sensitive private information. I think we've gotten much closer to harmonization. There's not the same overt concern about California in the United States Senate. You see all of the members who are not from California. However, we have gotten very hung up over the private right of action in the Senate. And it seemed for a while that we were going to be very close to a solution here. What we've ended up with, however, is Senator Wicker decided to break away from the working group and tried to negotiate a package with Senator Cantwell, the ranking Democrat on the full committee from Washington State. Unfortunately, Senator Cantwell and Senator Wicker couldn't get far enough in their negotiations, and it actually kind of went sideways, where Senator Cantwell felt the need to file her own bill, which really harmonized CCPA on a federal level. As a result, Senator Wicker felt the need to react and filed his own bill from a very conservative, pro-business perspective. What has been interesting is Senator Blumenthal from Connecticut, who many people see as the key to this negotiations, has stayed off of Senator Cantwell's bill. And he and Senator Moran have continued to negotiate to try to put a package together. I do not expect the Senate to have a package within the next couple of months. However, the Senate is still grappling with the scope of a private right of action. That is, in my opinion, the single biggest issue holding up their package. If there's not as motivating focus on the Democratic side and urgency to move, because there's no fear of CCPA as there is on the Republican side of what that could do to privacy around the country. But I do believe that post this election cycle, unless some major occurrence takes place this year in terms of another major data breach, I would expect post-elections, if status quo remains, meaning Republicans retain the Senate, Republicans retain the White House, and the Democrats retain the House of Representatives, that we might see a breakthrough in the Senate and an agreement that something has to take place. As a result of the stalemate, the White House, and I just want to touch briefly on the White House vision, the White House has gotten to the point where they have decided to start formulating their vision of how to manage federal data that emanates from the federal government. This is a significant amount of healthcare data. There's discussion of utilizing, because we use Spectrum, that this is something that they would preempt through federal regulatory action. If you're using Spectrum to deliver these services or any other federally regulated asset, there's discussion amongst the lawyers that they may be able to do this themselves. So the White House is looking at trying to craft a vision for a federal data privacy plan. and we will see how that goes. But they have been trying to yield to the Senate working group. So in the meantime, we're monitoring the White House. We do have more sympathy for a small business exemption in the Senate than we do in the House. And actually, in some of the draft legislation, there are small business exemptions. And in the White House conversations, I think there's a recognition that smaller ISPs in particular, who are not capable and structured in such a way to profit off of consumer data, should be excluded from some of the regulatory burdens that might come with any sort of executive actions. So we're working hard in the WISPA DC operation to make sure that the smaller ISP penalties and visions and burdens are recognized in this process, so that we can try to make any federal legislation the least invasive or burdensome for our membership here. So that's where we stand in terms of proposed federal legislation right now. We're working on about 10 different bills that are out there, some public, many not public. So.
And there's not one that's a really good one. Each one has its own issues and problems and definitional concerns. So, I wish I could say we could endorse any particular one. I guess we need to look for the one that is the least problematic, but there's not really one good one.
There's not one good public one, I would say right now. There are some good private ones, but I don't see those, though, ultimately, because Congress is the bastion of compromise. I think Janelle is correct. We're not going to have a perfect bill that benefits our industry and protects us solely. But I think the goals that most members of Congress that we've been working with on these packages, and I really emphasize this, most members that we have spoken to really are, they do not believe that either GDPR, the European version, which has had we can gladly add to where Congress's view is that GDPR has really only enhanced the business models for two companies and harmed every other business that's been involved in it. As well as CCPA, the data coming out of California that Congress is looking at, and one of our other clients that has been providing it is not having, one, the effect. Consumers are not scrambling for CCPA benefits necessarily, and two, the burdens it's having are tremendous. And again, it's only strengthening certain folks. And one of those other issues that GDPR that Janelle will touch on is there's what's known as opt-out versus opt-in issues. That issue in the Senate is a big discussion point because the difference between those two things makes two players in the world, not just 800-pound gorillas, but 800-ton gorillas in terms of data, where the smaller data providing companies who are engaged deliver much more benefits to the consumer. So there's the opt-in versus opt-out issue is still going to be a major portion of this discussion. Janelle, I'll let you touch on GDPR because this is something that Congress is following very closely the effects on.
Well, I call it the goddamn privacy rules. It's the European Union General Data Protection Regulations that went into effect May 2018. And at least GDPR, unlike California, it was under consideration and revisions and input and comments before it was adopted, years before it was adopted. CCPA's problems come because it was so hastily adopted within, I believe, weeks, written even within weeks, to avoid an even more egregious problem with adopting more serious laws at the voting and different process stage. But GDPR overall, let me back up. The EU in Europe, they do have what we consider constitutional privacy rights. They have always felt a very strong right for consumers to control their data. And GDPR just reflects that. And the data subject, which would be you or I or your employee, has certain rights, and GDPR requires certain disclosures and notices that companies have to give, as well as the right to opt out of data, the right to delete data. It requires all businesses to have a data protection officer. that reports to the highest level of management. And the key things that GDPR are the private right of action for security breaches, even for your employee security breach. And there are penalties up to 4% of annual global revenue. All of these laws, the state laws, CCPA, the federal laws, as well as the international laws in Canada and Mexico, and now we're looking at spraying across the world of people adopting GDPR-like laws, are trying to get to, as Ari mentioned, the 800-ton gorilla. You know, the Facebooks and Googles of the world. They're not reflecting on the business practices of much smaller providers, nor looking at the impact of what that does for your business model. And your compliance costs are huge. The EU enforcement started, again, May 2018, and we are watching even small companies in the EU get fined and penalties ranging from 40,000 to 14.5 million euros. And it doesn't take a big security breach. It could be you have compromised the data of a single user for a large fine because you didn't take the proper reasonable security measures. And then violations, the biggest violations I see have been unauthorized disclosure to third parties and failure to have a system that allows the data to be deleted. Again, they have a right to be forgotten, a right to delete data. CCPA has that too. Fortunately, as I mentioned, CCPA does allow you to retain data for legal and regulatory purposes. Next slide. I mentioned other laws. Canada, for those ISPs that are operating on the border, Canada has always been consistent with EU data security and privacy security. And in wake of the Cambridge Analytica Facebook data debacle, which, by the way, really drove the GDPR when that happened, the Canadian government has also revised and looking at GDPR-like amendments. And their enforcement, they're expected to increase against US companies because we're considered the outliers. We're considered the ones that don't care about your privacy and data. So we're expecting Canada to be more active on enforcement. We're expecting Mexico to be more active in enforcement. And overall, in the United States, the FTC, as in the Federal Trade Commission, has also enhanced their enforcement mechanisms. Ari mentioned that one of the Illinois issues that if the state AG brings a lawsuit against you, then a consumer shouldn't be able to pile on. Well, in other places in the United States, we see that piling on a regular basis. If there was a security breach, for example, that made the news because you had to disclose it and you had to file it with the state AG, not only do we see enforcement action from the state AG, but the FTC is also monitoring news stories. The FCC is monitoring news stories. And then, of course, the consumer privacy advocates and class action litigators. So you could get from one security breach or one just bad day lawsuits from multiple levels. That's why I said from the very beginning, there's increased scrutiny for ISPs. Great appreciation. Without you, we would not be able to survive this crisis when everyone has to stay home. And there's still people that are struggling that you as in WISP are reaching better than anyone else. But there is so much increased scrutiny and increased concern that ISPs are not going to protect the data, not going to protect the security of personal information, not going to keep your networks secure, and therefore expecting increased enforcement actions. Next slide. Here's your risk of non-compliance. If you haven't figured it out already, I've just put these as a checklist. You've got legal risk. You've got financial risk. Next slide. And as well as we've tried to give you helpful resources that you can go to find out what the requirements are. If you need more information, if you need a list of state data breach notification laws by state, that National Conference of State Legislators page is wonderful. It is on speed dial. I access it all the time because it breaks down by state what your requirements are and lets you know what's been amended. If you're not familiar with your state laws, I cannot emphasize enough, it's not just the federal laws that you have to be worried about, it's your state laws because you are operating in that state. You need to be aware of that as well. So overall, there's a lot to think about. I understand. There's certainly a lot to maybe bring in compliance with. If you've got additional questions, contact Ari, myself, or Christina. Again, we can't give you specific information to your business. You really need to hire counsel or work with a consultant in bringing your systems, your network, your employee training, your privacy policy, your terms of use agreement, which should also state how you're going to use certain information into compliance. We greatly appreciate your taking the time to listen through this and get through this very last slide. We know it's been a long presentation. Hopefully it hasn't scared you to death, but hopefully it has motivated you to do the right thing and to bring yourself into compliance. So thank you, everyone, and I wish you the very best of luck, as well as safe and stay healthy with you and your families.
Thank you so much, Ari, as Chanel. That was incredibly informative. To clarify, if you have specific questions, go right to Chanel. Ari and I will just direct you to her anyway. She obviously is a very knowledgeable expert on these issues, and she would provide good counsel, again, within the confines of her non-legal relationship with you. So quick question, just before we part. If I'm like, say, an average mid-sized WISP, and I listen to this presentation and I realize that I may have a privacy policy in place, but it's severely lacking, and you have sufficiently scared me to act and realize that I need to do a little bit better. Would the CCPA be a good starting point for modeling any kind of policy or system I implement in my company? Or do you think that's overly burdensome at this stage that, say I'm operating in Nebraska and I'm not aware of any customers who are in California, although like you said, there could be a student, there could be, situations that I'm not aware of. Would it be overly burdensome to just go ahead and comply with CCPA requirements? Or do you think there's a middle ground I can do as a small business who obviously has limited resources, but wants to be completely compliant in any way possible?
All right, I think that's a great question, Christina. CCPA is overly burdensome even for the largest companies, basically because the law just, in a word, sucks. It's written so poorly. It has conflicting statements, a lot of ambiguities. What we've been waiting for from California are regulatory guidance from the state AG's office that is mandated to issue regulations by, I believe it's July 1, on clarifying certain parts of CCPA, but yet we're now in our, I believe it's the third amendment of those regulations, and we still don't have anything adopted yet. Worse yet, those regulations may be retroactive on July 1. And even then, some of the regulations, some of the proposed regulations don't make sense. So I don't think that if you're pretty sure you're not have any consumers from California, I would not recommend compliance with the CCPA because it is so onerous. There's so much you have to do in disclosure. You pretty much have to upset your business model as well as, but there is a California law that I do recommend you follow, and that's the California Online Protection Act, which is CalOPA, we call it, Privacy Protection Act. It's the California law that requires you to have a privacy policy. Just a standalone, every commercial business must have a privacy policy. And it lists all the things that you must put in it. I basically have put those things in this presentation. So the page that I had that says the things you must disclose in your privacy policy is a good starting point. One thing about the privacy policy, your insufficient privacy policy. If you make a material change in your privacy policy, For example, if you have told consumers that you will not share their data for advertising and marketing purposes to third parties, behavior advertising, tracking, to your vendors, whatever, and then you decide as a business model that you want to share that data because you may get a percentage of that revenue, that's considered a material change because you made one promise in that first privacy policy, and now you're changing direction to the detriment of that consumer. You now have to go back to that consumer and get them to agree to the new privacy policy. You cannot just unilaterally change your privacy policy in material ways, change it, post it, and then expect everyone to be in agreement to it. They have a right to opt out of your privacy, the new privacy policy, and for you to conduct business under your old document. So that's a nuance. That's a nuance at state law. That's a nuance at federal law, particularly the Federal Trade Commission, which has oversight over your privacy policy, deceptive and unfair trade practices. And if that insufficient privacy policy, because you copied it off of somebody else's page, gives information about things that you're not really doing, you now have a deceptive practice. So that's a concern. So your question is, they need to update their privacy policy immediately, but do so in the most straightforward manner. I would not recommend CCPA because it's a mess.
And one final question, say I am just starting a WIS. These are issues that are all new to me. I didn't even realize this world of regulation, and I'm now a little bit nervous. You had some good first steps. What priority should I put this formulating a privacy policy and implementing it into whatever operations I have going on? What priority would you say for a small startup should I lend to establishing this privacy policy?
Well, as a small startup, before you even collect one data point from one consumer, you should have your terms of service. Even if you have a no contract business plan, meaning that they don't have to, a consumer or subscriber, whatever you choose to call them, does not have to have a year-long contract with you, that consumer subscriber must still be bound by your rules of the road. You still must have some guidelines, parameters on how that consumer subscriber uses your service, what they can and cannot do. That's your terms of use, terms of service, terms of use agreement. That's a written agreement they must agree to as well. That works in conjunction with the privacy policy, because the privacy policy should be adopted at the same time. That privacy policy then tells the consumer what you will do and not do with their personal information, who you share it with, etc. They'll have your CP&I obligations there. Those two work together, and they are cross-referenced. Your privacy policy should be incorporated by reference in your terms of service, terms of use, along with your service orders or other legal documents. So before you sign up one person, you should get their written authorization. Written means it can be electronic, it could be a click-through. It certainly needs to disclose what they're agreeing to and get an affirmative checkbox. Don't have a checkbox on your screen that's already pre-checked. That's not deemed to be an opt-in, that's deemed to be an opt-out. So they have to take an affirmative step to agree to it. Your terms of use, terms of service, whatever you call it, your privacy policy, your DMCA copyright notice infringement notification should also be part of this suite of legal documents to protect you, your investors, your systems, your network, your employees, as well as your customers. All those should be in place before you sign up your first customer. Ideally, if not, then get them implemented as soon as possible. Each one is related to the other. They work hand in hand.
Fantastic, guys. This was excellent. Thank you so much. Ari, Janelle, as usual, thank you for your counsel and guidance. And thank you to those of you who've tuned in. Hope you learned a whole lot.
Be careful out there.
Yes, stay healthy.
Indeed.